Hey folks, this is Jess, and we're here on One Take with Jess. I am Jess, the host of One Take with Jess. How many times can I say Jess? My guest today is Jon Bell. He is an attorney or lawyer. We talked about an attorney versus a lawyer and what does it mean? The answer is nothing.
That's right. Nothing at all.
He's an attorney out in Long Island, New York, specializing in labor and employment law, representing the employees and sometimes the employers. Hey, how are you doing, Jon?
I'm doing pretty good, Jess. Thanks a lot for having me on. And I think we're going to get into some very important information that everybody should know, whether or not you're an employee or an employer, but especially if you're an employer and run a small business. So listen in. We're going to protect you from some huge exposure of potential lawsuits. So if you listen, you're probably going to make some immediate changes to your business that could save you a lot of time and money.
Yeah, that's wild to think that as someone who opens up a business, whether you hang out a shingle or start employing people in your community or around you, that you're opening yourself up to litigation. And I guess we live in a litigious society, so for every wrongdoing, everyone's looking to blame someone. So it's I mean, thank you for giving us fair warning as to what we can do to mitigate those risks as entrepreneurs or employers.
First of all, if you have a brick and mortar store, you should really listen to this part, because I'm going to save you a lot of money, a lot of headache, and really, you should be doing the right thing here, okay? The Americans with Disability Act has something called Title III. This has been around this year is actually the 30-year anniversary, okay? Title III stands for the proposition that people with disabilities cannot be discriminated against as long as you offer some type of brick and mortar store. You're a place of public accommodation. That's the phrase. You're a place of public accommodation. So what does that mean? If you want a flower shop, a pizza store, a bank, anything where you get patrons off the street to come into your business has to be ADA accessible. Now, the Department of Justice can't prosecute these cases. So what they did is they gave a private right of action to attorneys. So what happens is, so this is the good and this is the bad. It's the difficult part of it, it's 100% liability. So if someone with a wheelchair goes to a store and they have a step and they don't have a temporary ramp, or their bathrooms are not accessible, they're accessible to able-bodied people, but not people with disabilities, specifically people in wheelchair. They don't have the rails next to the toilet, or it's not big enough for a wheelchair to fit. Those people can be sued, and the plaintiff, the person who's suing, will definitely win. It's not about not affording a lawyer. And it's a draconian provision, meaning that the defendant, the store owner, will have to pay damages to the person in the wheelchair, normally around normally about $1,500 less. About $1,500. They have to pay the plaintiff's lawyer's fees. That's could be anywhere between $5,000 to $20,000, depending on how much they fight it. And They have to pay the defendant's legal fees. So I understand the mindset of business owners saying, hey, this is not fair. This wasn't intentional. I wasn't aware of it. They should at least send me a letter first, give me notice, give me an opportunity to correct it. And that kind of makes sense. I don't totally disagree with that.
Right.
But on the same token, the way the law is, hey, if you're an employer, if you have the money to open a store, you should do your due diligence and you should have the knowledge and figure these things out. Contact the lawyer, speak with them, have a consult, whatever it might be. Now think about it from a parent or the person who's in the wheelchair. Let's say I have a child. God forbid I have a child in a wheelchair, and all I want to do is go out, get some ice cream. I go to a local Carvel. I know that they're supposed to be accessible. Kids want to have Carvel ice cream. There's a couple steps. So I go up the steps. I say, hey, listen, my kid, I want to bring him in here. Is there a ramp? And they say, no, there's no ramp. And I'm on the board of the Long Island Center for Independent Living. Listen, they advocate for people with disabilities. So a big case was a Title III accessibility case where the Long Island Railroad, they need to utilize it to get to work. There were certain platforms without elevators. There were certain trains that came in with gaps literally this big that you couldn't get in or off the train. So it's not a perfect rule, okay? There are always scenarios of people abusing it, like you described. There are lawyers out there. It's terrible. There are lawyers. They'll do like a Google Maps search, and they'll look for stores specifically with steps in. So automatically they know there's at least one violation. That's all you need is one violation. They'll send their client with a wheelchair in or attempt to get in, and then they'll start a lawsuit. It's not just a step. The counter height has to be right. You can't have, in a bank, if you notice, a lot of them are, the counters are up to here, but then there's always at least one with a dip. The parking lot has to be accessible. Depending upon the number of spots you have to have the right number of parking spaces. You have to have a clear path that doesn't have a huge ascent or descent to get into the, so there's a lot going on. So
I even read in one of the articles, someone was suing because the mirror in the bathroom was too high.
That's
and you couldn't see.
Right, but that's one of many violations. So understand that, and I sent you the articles to kind of show you what I'd like to talk about.
Right.
But I also sent you the New York Post, which is a very conservative article, and there might be 10 allegations about 10 things that are wrong, but the Post might pick out the most ridiculous one and say, okay, here, no one's suing just because of one violation, put it that way. There's usually multiple violations there. So some of it is, media spin, and we all know that that exists to a certain extent. And I've advocated, and one thing about me as an attorney, I say it like it is, okay? Yeah. I see it being fair and unfair on one side and fair and unfair on the other side. And, but hopefully at the end of the day, people will want people with disabilities in the store. It's just another customer base. It's more customers for you.
So what you're saying is that if you have a store or you are an employer as well, or, vice, whatever, it's your job to make sure that you have checked all the boxes for these potential, litigation instances, because you have no chance as a store owner. If they come in and they throw a lawsuit at you, you have no chance. You're going to have to pay the $5,000, $1,000, $1,500, probably $30,000 before you sneeze. And you really need to make sure that
you're going to have to fix your store. You're going to have to pay to fix your store, pay the attorney's fees, both plaintiffs and defendants, and play a violation. So what I'm telling you guys now, just fix the store now. Yeah. Contact me. I'm not even charging for it. I'll walk you right through it. I'll tell you who you have to contact. We'll get an engineer over who's specialized in this stuff, give you a full report about the violations. Fix it now before it's an issue and before you're paying a lot of money.
Yeah, that's great. That's, if anyone walks away with any bit of information.
There's difference between, there's structural defects, which are really the landlord's responsibility, and then there's defects within a store. So let's say you're a restaurant. You open up a restaurant. The steps in front, you can't do anything. The landlord has to do it. However, the height of your table, that you have to do it. How accessible your tables are. The aisles that go through have to be a certain width. So if someone, let's say you have an accessible table in front, the bathroom's in the back, if the tables are so close together they can't get through, that's a violation. So
wow.
just be smart. So
can anyone call you, or do they have to be from New York?
And this is federal law. Anybody can call me, and I offer this as free advice. Okay, because again,
this is good stuff, guys. If you're a store owner, if you're a business owner, call him. Seriously, he will definitely guide you through what you need before a lawsuit comes. And everyone is, now I say everyone, but I think maybe even more so for the pandemic and because of people's financial situations, they are looking for someone to blame. So even if it's not COVID related and it happens to be something related that you touched on, people are looking to blame and to get money and to do that. So
listen, this applies to law offices too. I've seen law offices be so. I mean, sometimes I go to a law office where they, it's someone, he hung up a shingle, he bought himself a little building, he's very proud of it. Then all of a sudden there's steps to go in. I've seen steps to go into an elder law practice. I'm like, wait a minute, are you kidding me? Like, I'm sure you have some clients that are in a wheelchair. Like, just get rid of the step and make a ramp. It's so easy. And
you could make a whole show out of this. You could have someone follow you around with a camera and go knocking on doors of store owners or, law firm owners or everyone and be like, do you see the step outside? Like you could just walk through, point through, go to the next.
If they decide to make the day from 20 hours to 30 hours, I would definitely do it. No time. But getting this information out there is critical. And then, So now segueing into the other articles I send you because it's along the same lines. If you have a website, it's the same ADA law, Title III, that covers those websites. So what does that mean? If you put up a website, whether you're a lawyer, whether you're a restaurant, a clothing store, it has to be accessible. What does that mean? It means that you can't have a picture on your website that says, here's a 25% coupon, 25 off, if it can't be read by that software, right? So you have software that the blind utilizes to read your website. If there are
I'm writing
pictures
this
on
down.
there, if there are pictures in there that are not embedded, that can't be read, and where someone who's blind could listen to it, and it says, this is a picture of a 25% coupon, you could technically be sued the exact same way as these brick and mortar places because your website is not accessible.
Wow.
Now, let me give you another example. That's most cases are by blind people because again, it's not compliant.
Okay. This
do me
is
a favor,
huge
Jess,
because
when you get a
everyone
chance,
opens up a website.
when you get a chance, go on my website. You'll see something on the corner that says accessibility. You click on it. It's a free service. You download it into your page. It could change the size of the font. It could change the shading so people could view it. It's an excellent. I forget what they're called, but you just kind of click on it and it appears.
Okay. What's your website address?
Bell LG. So 3 L's. Bell LG, as in belllawgroup.com. So then there are people who are not blind, but they're deaf. If you have videos on your website, what does the videos have to have? So the deaf people have equal access to the videos and information.
They have to have subtitles or closed caption?
There you go. Required. If you don't have that, you're opening yourself up. Again, pay the defendant's attorney, pay the plaintiff's attorney, pay the person suing. Or you could take my advice, do it now, save yourself a lot of headache, a lot of time. There are companies that specifically are out there that are not very expensive, and they will make your website ADA. So, you know, the scariest thing, Jess, about this whole thing is the fact that, you know, as you see me around, I'm very much into marketing and talking to people and getting my name out there. I've interviewed so many people to do my website. Their marketing is they're experts, this and that. And I say, listen, I'm considering using you, but I want to make sure that my website's ADA accessible. They say, what is that? These are people, Jess, who do this for a living, and they don't even know this. Again,
yeah, I have to check with my Shopify people and see if that's ADA accessible.
You got to do it. There are actually, and this is the crazy thing, and this is what makes it very easy to sue for this. And this is big business. There are lawyers that this is all they do, and they have a very robust, profitable practice because it's just one after the other after the other. So there are websites out there where you could actually Google like free website ADA checker, and then there's a website that will come up.
Mm-hmm.
Click on that website. You put in your own email. You put in your own website address.
Okay.
It will go through and it will tell you exactly what your violations are, which is insane. So great tool for you. Great tool for people with websites.
Yes.
But what about for the lawyers? The lawyers now they don't even have to get their client out in a wheelchair to go visit a store. They literally will go on my website, on your website. All they do is click it, run. They see violations. They do a quick summons and complaint, file it. You're in for at least $20,000.
Oh my God! Oh my God!
Insane?
I'm like dying now. I just wish I never heard any of this.
Right. You know, these and again, I'm phrasing it in a sense that, you know, everyone thinks, oh, this is gross, disgusting. Again, I do see the other side of it. I do believe it's a 30-year-old law. I do believe that people with disabilities should have equal access. I understand. So I know that I differ with a lot of people like, oh, you're just a disgusting lawyer. But no, I really do believe people have access. But it's important for people like me to really do the right thing. And you, what you're doing right now, get the knowledge out there so people understand this and they can make these changes and avoid a lawsuit. And guess what will happen also? Now you're picking up new clients that wouldn't ordinarily go to your website because they can't view it or they can't hear what's on there.
That's true. That is true.
Yeah.
And it's funny that you said that you were an introvert because you
I
can't
think that
tell
was
that
off
you're an
camera. I don't know if I wanted that to be on camera, but but listen, just like anyone else, you start getting me talking on things that I'm interested in, things that I do for a living, that I'm very passionate about. And I'm not talking on camera right now. I'm just talking to a friend about things that I really
Yeah,
care
and I have a
about.
lot of homework to do with this whole ADA accessibility and compliance thing on my end. So I'm
Yeah,
sure that people who are watching this will make notes and get going on those types of
right.
things.
So
But
the next trend, I just want to finish. I just want to finish full circle. The next trend of lawsuits that are being filed now, because the brick and mortar wheelchair has kind of been played out. The websites are now getting played out. Now lawyers are suing big companies. Usually you start with the big companies, and then when they get in compliance, you kind of work your way down to the medium and smaller size companies, is gift cards. They're saying all gift cards have to have Braille on them now.
okay, what if it's an online gift card that's printed or using? Maybe that's a dumb question.
I don't have an answer for you. I see that
But the amounts
there are
change. How would they
big
reprint?
companies, big
How would they
department
reprint
stores.
the amount on the gift card if the amount changes? So you use it once, you have $6.48 left. How would they reprint the?
Well, think about it. You don't have to give people with handicaps extra access. So, for example, when me and you use a gift card, we don't know exactly how much. It doesn't say anywhere. So,
Right.
so you don't have to give them extra rights. It wouldn't be different from an able person, right? When they give me a gift card and I use it, they don't come and they tell me at the register, yeah, you have $20 left, you have $10 left, but it's not actually on the gift card. So you don't have to worry about that, but you do have to say, at least originally, this is a Bloomingdale's gift card, and you have to have it's also a good idea, in my opinion, it's a good idea, and maybe it's a little bit more costly, but we're presently printing business cards. Again, I don't see any lawsuits on it yet, but I'm printing business cards with some Braille on it too.
Yeah. Oh, that's good. That is good. Maybe they could actually put a sticker on the gift card,
Yeah,
right when they sell it, that
there you
has the
go.
braille part of the amount
Yes,
if they're not.
sure.
Interesting. Very
Yeah.
interesting. Interesting. And I'm going to throw one more thing in there, which is, I don't know where this falls under, if it's like an American Disability Act thing, or if it's just a disadvantage for certain classes of people. But my question is related to older people, and older people being disadvantaged, maybe that they don't have whether computer access at all. And some things are exclusive to computer access. For example, the unemployment system down in Florida. My parents are older people. They're in their 70s. My dad's in his late 70s, but he's fully employed. He has a business. He needed to go onto the unemployment website because the phone system was completely, first it wasn't working, then it was wait times of like 16 hours. But he wasn't able to do it on the computer because, number one, it wasn't accessible, like it wasn't working. And number two, like there are older people that don't even have computers. So how are they able to access certain things that are supposed to be accessible to all, when whether age is a disadvantage, age is not a disability, but you're now losing accessibility as you get older. And not everyone does have 100% connectivity. So you can't assume that things that are exclusively website only are really giving a fair chance for people to access it.
Yeah, so it's basically the same answer. Like just like race, and just like national origin or whatever it might be, there's no laws for accessibility protecting other groups other than disability. So yes, it's true, and it's it would be nice actually if they did have some accessibility for the elderly and things under that circumstances. There's no federal or local laws that really cover that specifically. However, there are a lot of people, elderly people, that actually do have a disability and do essentially qualify under the ADA Title III, where they can essentially have a lawsuit. Now, talking specifically about unemployment, I first of all, the computer is of course the most efficient way, and you're going to get your results a lot faster. But my understanding from it is that there are telephone numbers that you could call, that you can mail in an application. There's other ways to do it, but there's, speaking of like legal rights, there's really no legal theory of saying, hey, this is not accessible to my father because he's part of this protected class, which is over 40, by the way. We're part of that protected class too. Is that a secret or not a secret
What
for
kind of
me?
protections do I get over
Right,
40?
right. But yeah, we do get, believe it or not, we get certain protections. Like for,
Really?
yeah, let's say for example, so you're self-employed, you're an entrepreneur, you run a great business, but let's say that you were an employee, right? And and let's say you were being, for some reason, terminated for some reason, and they give you a severance agreement. Because you're over 40 now, they have to give you a certain number of days to not only review it, but once you sign the severance agreement, they give you another 7 days that you could renege and say, no, I don't agree to the severance agreement. When people who are under 40 don't have that right, they could say, this is your severance, take it or leave it. So there are certain rules. Or for example, we handle age discrimination cases in the past where people apply for a job, they're not selected for the job. Meanwhile, they'll find out someone 20 years younger than them got the job that has less experience, and they think that their age is the
Discriminatory
factor why they weren't selected for the position. So then the natural question is, well, okay, you feel like it's discrimination. I understand discrimination may play a role. However, were they going to pay you the same amount? If you got the job, do you know if they were going to pay you the same amount as they got this other employee? If the answer is, well, of course, the person's less senior, they're going to pay them less money, there's no case, because now the employer, the key to defending discrimination cases, so everyone knows, is showing that you have a legitimate, non-discriminatory reason for doing it, for taking the action. That's the phrase, legitimate, non-discriminatory reason. So if some novice lawyer takes that case and say, hey, you discriminated against him because of his age, they're going to say it had nothing to do with this person's age. That person, your client, wanted $100,000 a year. This person, 20 years younger, accepted the job for $60,000. I don't care what their age is. The company wanted to save $40,000.
Right.
However, if they're paying that person this, let's say they advertise what the pay is, and they paid that person the same, that is a big step towards proving discrimination. But again, circumstantial evidence. Guess what might happen? They say, you know what? Yes, we recognize there's an age difference, and we recognize that we would have paid the person differently, and we even recognize that your person had more experience. But guess what? The person who we hired, this is a private company, and this person was my second cousin. Hey, free country. You're allowed to hire your second cousin and pay them more without any with less experience. So as long as you have, in any business decision you make, if you formulate a legitimate, non-discriminatory reason, you're safe. Now,
and you might even want to stick that in a file, because you might not even know why you hired your second cousin or whatever. So when you're doing the hiring, make all of that, formal, and stick it on a piece of paper and stick it in file, just so you know.
That's a great idea, because now you're doing a contemporaneous document with the decision, and you're not doing it responsive to a lawsuit. Because if a plaintiff's lawyer is going to argue, well, you're just doing that because you're just coming up with that excuse because we started this lawsuit. But if you do that contemporaneous, that's a great defensible case. Giving your listeners more advice that's very, very important is anti-retaliation. If I work for a company and I say, hey, I'm being treated differently because I'm a Jew, or I'm being treated differently because I'm over 40, and then let's say they actually do what they're supposed to do. They do an investigation and they ask people what happened. And let's say they come to the conclusion that, your allegation, you might feel that way because people feel certain ways, but you're 100% wrong. It wasn't discrimination at all. And this is the reason. You still can't discipline that person who made the complaint because there's anti-retaliation provisions. The way the law is written is they want you to feel free to make a complaint if you feel like you're being discriminated against. So I've handled cases in the past, which have been very successful, where an employee makes a complaint. I'm being treated differently. I'm African American. I feel like I didn't get a promotion because of my race. And then all of a sudden there's an investigation. They find it frivolous, and then they fire that employee.
Yeah.
They come to me. I'm salivating over that case. I'm literally salivating over that case because it's a very good case, not very defensible. A lot of times they'll put in writing. Well, she filed this complaint. We did the investigation.
Oh,
and we found it to be frivolous. I'm like, oh my God, this is like one of the greatest cases I've ever seen.
Yeah. Is
So
that
you
an
got
easy
to make
win?
sure that
Is that a slam dunk? Is that an easy win?
you can't get a clearer case. Retaliation cases. So my two favorite types of cases involving discrimination are retaliation cases, when somebody complains and
Mm-hmm.
then there's an adverse action against that person very close in time. I love that case. I'll sign that case up on a contingency any day of the week.
How close in time are you talking close in time? Because again, this is for the benefit even of people who are business owners who may want to get rid of an employee. The employee actually files a discriminatory claim, but they really wanted to get rid of the employee anyway, you know, so how long do they have to wait before they can legitimately fire that employee?
Okay, so that's a great question. I get that question a lot because a lot of people, a lot of times, and again, I represent employers too, so I see it from both perspectives. A lot of time, an employee who thinks they're in trouble and not doing a good job will then go and make a complaint and think that they're being protected, right? So so even if you fire them, first of all, I recommend against it, but even if you fire a day or two later, the question is, before the complaint happened, did you document the bad performance? Did you document the fact that they were coming in late every day? Did you document the fact that their performance was not up to standards? Did you have conversations with these employees, maybe put them on a performance improvement plan and have them initial the fact that you've had these conversations? Because even if they complain of discrimination, and let's say you fire them a week or 2 weeks or a year later, and they now start a lawsuit on discrimination, you could say, hey, it had nothing to do with that. All this stuff, all this documentation that we did predates it. The worst thing that you could do is do nothing and not confront them. The worst thing that you could do is give them raises and bonuses just because, I feel really bad. I'm just not a confrontational person. That's the worst thing. I understand it because I'm not much of a confrontational person in my personal life. As a lawyer, I'm very confrontational. But when it comes to like personal situations, I tend to shy. I'm like, let it be what, let it be. So I have to actually force myself to have those uncomfortable conversations with my staff and saying, hey, listen, you really need to do A, B, and C better and sign it or misconduct. I'm giving you a warning. We had that recently in my office. I had to give a lawyer a warning and it was uncomfortable. I actually liked the lawyer a lot. They worked hard. But I said, listen, what you did, you're really giving my hands are tied. Please sign that you have this warning and I'm making it part of your file. And it is what it is.
How often should we do that? Quarterly? Is it quarterly that you should do that with your employees?
It's not even quarterly. It's whenever somebody does something that warrants it. Maybe you don't give somebody if they don't have performance issues, you don't have to give them anything. If they engage in some misconduct, you want to do it. You don't want to wait till time passed. You want to do it pretty timely. If there are witnesses, you might even want to get witness statements from other people saying this is what happened, and then you give the person a chance to explain themselves, but you better document it. And Jess, this is really where the problem comes within the employer-employee relationship. This is the biggest problem, is that you spend more time with these individuals than you do with your family. So then there's a blurred line of, are they my friends? You have certain feeling, not necessarily romantic, but you just have feelings of camaraderie, of friendship. Yeah. You gotta understand that this is a business and there are laws and you can't be too friendly. For example, one of my clients and very good friend, he runs a famous tattoo shop. Okay, this guy is really, he's a genius. He opens his book one day a year, and he's booked out within 4 or 5 years.
Really? Did he ever give you any ink? Do you have something like?
He's always told me that if I want it, I got it. I just don't have it. And he's always told me that if I have a friend who wants it, that he'll make an accommodation. So we're very close. He's a neighbor. Really, just one of the greatest guys. And
oh, come here. Sorry, my dog's
you got to understand his situation is he's in a tattoo parlor, right? And his staff are not the white collar professional, right? So they don't want these rules. They don't want that. They laugh at the sexual harassment training that's required in New York. They want to talk about their dates and what they're doing in the bar fights.
Yeah, everything's a lot more casual, less stuffy.
So I'm telling him, I said, listen, you are a brand now. You are a business. I know it's difficult, but they have to understand that they can't talk sexually explicit in front of other employees, because even though the other employees might be engaging in it, once you fire them, they're going to come back and say that they weren't comfortable with it, even though they were at the time.
Yeah.
And they're going to have, who knows, recordings, emails, text messages, and saying, look at all this crazy things about sex and drugs and whatever they would talk. And the employer did nothing. And guess what? They actually have a decent case. So we have a lot of funny conversations, and we butt heads sometimes about what they're supposed to do. But I always get my way, because I show him, I said, if you don't do it, I show him cases, this is what's going to happen.
Yeah, but he can't have like a piece of paper that someone signs when they start working, releasing him of all like obligation.
100%. You cannot have a piece of paper that somehow holds you harmless for violating the law. It's the law.
It's the law that you can't talk about your date?
You can't. So you could talk about a date, but you can't go over the line of being graphic.
You can't make someone feel uncomfortable.
In other words, sexual harassment is a huge issue right now across the country. The Me Too movement, especially in New York. Okay, if I am working next to my employee, and I'm not even talking to my employee, but I'm not even talking to the person sitting next to me, but I'll talk to somebody else.
Mm-hmm.
And I describe what we did on a date, and start getting sexually explicit. This person might become uncomfortable, and they should not be subjected to that in a work environment. It's not appropriate. So the employer has to, if they're aware of it, or they should have been aware of it, have to take action. Now, if I'm just an employee, let's say I'm an employee, and I sit next to somebody who I think is attractive, and I start to sexually harass them, and that person never tells the employer, they can't sue for, anyone could sue, but they wouldn't be successful in a case, because the employer has to be aware of it, or should have been aware of it. But if they made a complaint and the employer did nothing, they're going to have a problem. Or if people talk in a sexually explicit way all the time, then the rule is, well, they should have been aware of it because it's constantly going on in the workplace. You have to understand, the workplace is not your family, not your friends. It has to be a very sanitized environment. Not saying you can't joke around, but your jokes can't go over the line of being sexually explicit. Stay away from racial type jokes. It could just be very good-natured humor.
So I work at home with my husband, Vlad, as you know, and he's a little too sexually explicit.
Well, so
I think I'm going to file a complaint.
Yeah, the conduct has to be unwelcome. That's the rule. If the other person is a participant in the whole situation, it's totally defensible. Tell Vlad to call me.
I will. I don't know if he'll pick up some tips or get some correction.
Right.
But for the employee, on the employee side of things, if you are being, if you do overhear conversations or being spoken to in a sexually explicit way and you're not comfortable, I would assume that you'd probably also advise for them to document as much as they can with dates and circumstances, even before they go to the employer to make the complaint, because they're going to say, well, what are you talking about? Big deal. He said it once. And you hold up like a whole sheet and you're like, nope, he said it like 40 times over the past 2 weeks.
And that's a good point. I'm talking to, you own your own business, so I'm talking more from the employer perspective. But I also, I do a lot of employee work. So when people call me with this situation, what should they do? So the answer is yes, they should document. And number two, they shouldn't just have a verbal conversation. They have to email it, because basically one of the defenses that employer gives is, well, she never made a complaint to me. And the plaintiff says, what are you talking about? We had like 5 conversations. Like, I don't know of it. And it's the burden is on the person who brought the case.
So even if you
walk, they're going to have to establish that they made the complaint. If you have an email, you have a date and time, it's undeniable that you made that complaint.
Right. That's a good point. So even if you do physically walk into the boss's office and you have the conversation, when you get back to your desk, you say, thank you for your time. Here's what we talked about, and blah, blah, blah.
In summary, that's the best practice. And what you should do, other than doing that, print that email right away and put it away, because I've seen some scary things where the person goes out, fires them, locks them out of their email, or you know what, you could either do that, or if the printer's not accessible, BCC your personal email address.
Yep. Yeah. All
And
these
also, yeah,
tips.
not that I tell people to do this too often, but at least in New York, it's a one-party consent state, meaning that if me and you are having a conversation face to face, I could record the conversation, and I don't have to tell you that I'm recording the conversation.
Mm-hmm.
And if you do that, then you could use that. It's admissible in
It
court.
is admissible.
Unlike Florida, Florida is a two-person consent state.
Mm-hmm.
So if I want to record the conversation, I have to tell you, by the way, I'm recording this conversation, or else it's not admissible. It's actually criminal. Okay. But you also have to, it goes a little bit deeper than that. You also have to look at your employee handbook. Sometimes the employee handbook says you're not allowed to make recordings without the other person's knowledge. It's still admissible, but you could be fired if you actually recorded somebody. Now, again, going a little even more technical, if you're a federal employee, federal law applies, and federal law is not a one-party consent, it's two-party consent. So there's a lot of differences involved. But you can, one thing you can't do, by the way, because it's one party, meaning you have to be part of the conversation. I can't put a recorder in my boss's or someone's office and then leave the room and not be part of that conversation. That's illegal and would not be admissible.
Okay. This again is really important information because everyone's got their phones, everyone's recording stuff, and yeah. So who needs to be alerted and who doesn't need to be alerted, and what you can do and can't do is really important too. So that's great advice. Perfect. Right. Love that.
Excellent.
So
it's up to you. Do you want me to transition to the next category of where people screw up, or you?
No. I actually want to shift gears for one sec because now that people are like working from home more often, they're going to be looking for, and kids may be going remote and still being at home. People are still going to have to try and get work done. So parents are like deciding how they're going to handle their lives with their kids now still doing schoolwork at home. So that just brings me to the conversation that you and I had regarding nannies and bringing help into the house for your family. And you touched on a very famous, case, or relatively famous case that is still ongoing, or no, it was settled. It was settled.
No, the case was resolved. Yeah.
Talk about that, because that is a big thing that people think if you're just going to bring in help and pay someone, cash or something, you really might get in trouble for that. So please carry on.
So this is good information for anybody who has a nanny, but it's also good information for any employers. So really the laws are very similar. Okay. Now I can't talk about the specifics of the case because the case was resolved and it's subject to confidentiality. So I can't go into the case, but I could just, what a lot of people do wrong, and a lot of people in my neighborhood, lawyers do it, doctors do it, everybody does it who has a nanny. You can't pay your nanny or any employee who's supposed to be hourly a flat fee for the week. These are hourly employees. They are non-exempt from the FLSA, Fair Labor Standards Act. So what that means is hourly employees, these are the rules for hourly employees. You have to keep track of the hours. You can't just say this person worked from 9 to 7. If they're working 8:45 to 6:45, or you have to keep track of those positions. So really, if you want to do it correctly, you should have your nanny literally doing a sign-in sheet every day, noting the time she's on and noting the time, he or she, to be politically correct, knowing the time he or she is on or off the clock. Okay.
I have to ask a quick question though, right in the beginning. What is an hourly employee versus someone who's just, flat fee? Does it depend upon what sort of contract you establish in the beginning?
No.
And is it under 40 hours a week where you become hourly? Like what makes it an hourly?
So most people should be categorized as hourly employees. The exceptions to that, there's a professional exception, such as lawyers or doctors. So if I hire a lawyer, it doesn't matter what I pay them, and it doesn't matter how many hours they work. There's a professional exemption. It doesn't. The way the law is, it's supposed to protect people who normally get taken advantage of. They figure that if you rose to a certain level in your career, you're considered a professional. So we're not going to protect you. Those are known as exempt employees.
Is that salary?
The standard exemptions would be professionals. The standard exemption would be a supervisor. If you supervise other employees, they can make you work 70, 80 hours a week, whatever it might be. But the thing is, to be a, but you can't. So this is the trick, and this is where people get into trouble. A lot of times, let's say I have a clothing boutique here in Huntington, Long Island, and I don't want to pay them overtime, time and a half for over 40 hours. I'm going to say, you know what? You're a supervisor, and you'll make $60,000 a year. But in reality, the person just sells clothing. They don't supervise anyone, or maybe they supervise someone really minimally, but they're really doing the work. They're going to look at that, and you're going to be liable. You really have to supervise at least 2 full-time employees, and the vast majority of your role has to be of a supervisory nature. So that's the key. So if you're going to pay somebody and you want them exempt, we give them a flat fee. First of all, the thresholds, and they're always changing, are different if you work in New York City, if you work in Long Island and Westchester, versus if you work in the rest of New York State. These are New York State laws. There's also federal laws that are very similar to New York State, but the threshold to pay somebody in New York State and New York City is higher than the federal law. So you have to pay them a certain amount, and they have to properly be exempt. A nanny is not going to fall under that category. A cashier.
Okay, I'm gonna pause for 1 second again and just ask another question, because I'm still not fully clear. If you work for a company, let's say I started working at a bank and I'm a salaried employee, it doesn't matter if I work 40 hours a week or 60 hours a week, I'm not getting overtime because I'm a salaried employee. So how does that, again, I know you said the exemptions are for professionals, but why can't a nanny be a salaried employee still?
Right, because it's strictly because the FLSA and New York labor law doesn't allow for that. Okay, you could be a salary if you meet certain exemptions. You don't have to be a professional. Like I said, the most popular one is a supervisor or managerial exemption. So if I supervise a staff, you could put me on a salary. So the biggest mistake small businesses make is they give someone a salary and they say, well, this person agreed to it. Like, why are they coming? Yeah, they worked 50 hours a week, but I paid them pretty well. I paid them $50,000 a year. Why could they come after me? I advertised the job as a salary, and this person accepted it. That goes to my comment before. You can't agree to violate the law. You have to look.
So weird. I would never have thought that would be a law violation if you're putting the job out there as a salaried position.
That's why these lawsuits are, first of all, they were really more rampant, I'd say, 10, 15 years ago, especially against big companies. Some big companies would misclassify people and call them independent contractors when realistically they're employees, and they did that because they didn't want to pay overtime. Or some people wrongfully put people on a salary when technically they were hourly. A lot of lawyers made a lot of money on these cases because, let's say, for example, and again, so I'm going to go to the unfair scenario for the employer. Let's say I advertise a job. I say, listen, you're making $50,000 a year, and I don't care how many hours you work. Oh, actually, work 50 hours a week. I'm going to pay you $50,000 a year. It's a good salary for what you do. You're like a cashier that, you should be jumping up and down and being happy. And let's say the employee is happy doing it. They still have a very, very strong lawsuit because they are supposed to be hourly. They're supposed to get a paper at the beginning, explain the fact that what their hourly rate is, what their overtime rate is for time and a half over 40 hours. They have to have the name of the company on it. They have to have the telephone number of the company. These are all violations that every violation you have is going to cost you money as an employer. So now let's go to the opposite situation and arguing why it is the law in favor of the employee. Let's say that you're an immigrant, you just came to this country, and you really have no money, and you're desperate. And an employer who has plenty of money but looks at someone that could take in like a landscaper and says, you know what, I'm going to throw you $200 a week. I'm going to make you work 80 hours a week. I'm going to get rich off of it, but you're making $200. That's your problem because you can't get anything else. You're an illegal alien. And I'm going to run all the way to the bank and take advantage of you because you don't speak the language and you don't think that you have a lawsuit. Guess what? They have a very good lawsuit. So it works both ways. So nannies have to be compensated. There is a exception that if you are a nanny that's a sleep-in nanny, in New York, you have to pay overtime, not over 40 hours a week, but over 44 hours a week. There's like a domestic worker, New York Domestic Workers Act, that if you have a nanny, you should really read it. Now, this is where things get get a little bit more dicey, Jess. Someone might call me and say, hey, I heard you. I was listening to this, podcast. You provided very valuable information. I'm freaking out. I have a nanny. What do I do now?
Well, I'm freaking out and I don't even have a nanny, but yeah, right. I could imagine you getting that phone call.
And that's an uncomfortable discussion. And I'm going to say, listen, really, there's no good answer. I could tell you that most times nannies don't sue. They want a good recommendation. But if you do terminate this person and then you ultimately hire another nanny, do it right. Get workers' comp insurance. Put them on the books. Take out the taxes. Track the hours. Pay them time and a half. That's what I do. Is it fun? No, it's not fun. If I did it wrong, I would be on the cover of the New York Post.
So don't people, a majority of people maybe pay their nanny in cash, the way that they pay their cleaning lady in cash or their landscapers sometimes in cash? How do you deal with that?
They're all exposed. They're all exposed to a lawsuit. Nanny lawsuits are becoming more and more popular because it's shooting fish in a barrel. You're dead with liability. In other words, let's say the nanny says, and this is a very interesting part of the law. Let's say the nanny said, you know what? I worked 75 hours a week and they paid me $500 a week in cash. And so they didn't pay me overtime. Let's say the employer says, you didn't work 75 hours a week. You worked 40 hours a week. What are you talking about? The burden is on the employer because it's the employer's, it's like different. Most times the burden's on the plaintiff, the person bringing the case. This is the only type of law that I know of where the employer, because they're under a better position. Well, if you're saying that this nanny only worked 40 hours a week, well, let me see the time slips. Let me see the time records. And the defendant always says, or the owner of the house says, well, I don't have it, but they don't have proof either. Too bad. Whatever they say, if you don't have your records as an employer, because you're still an employer, whatever the plaintiff says is what happens. So now let me explain to you the damages part. Okay, let's say we do a damages calculation. We say, okay, based upon what my client is saying, technically, you shorted them $20,000 over the course of 2.5 years. So you would think that the defendant's like, you know what, you're right. I don't want to pay for my lawyer. I'm going to write you a check for $20,000. No, you can't do that. Because the way the law is if you owe them technically owe them, rightfully so, $20,000, we are going to punish you and now double that. So now
who's going to punish? Who decides they're going to punish?
The law. The way the law is there's a double damages provision, both in federal law and state law, which says that if we calculate that you owed them, that you shorted them $20,000, you have to now pay them $40,000. And not only do you have to pay them $40,000, but you have to pay the legal fees of the plaintiff's attorney who brought the action. So you might say, well, that's totally unfair. Why would they do that? The reason the law is written that way is that if it wasn't, then every employer, the way that it looks like is every employer would do that to an employee and just pay what they owed. They try to get away with it. They want to make sure that the people who wrote the law, both the federal and state and city law, they want to make sure that people aren't trying to get away, aren't trying to screw the employees over for money that they're entitled to. So
and it sounds like they also want to make sure that the person is on the books in order to get the taxes from, the pay.
Well, not necessarily, because illegal immigrants, they're covered under this law. So you could be illegal, never have paid any taxes, and still have a very, very valid lawsuit. And so then.
But wouldn't you still need to be on the books, though? Like, wouldn't you still have to pay? No. Oh my God, now I'm thoroughly confused.
But do you know why that is?
Because I have blonde hair?
No, I'll tell you exactly why that is. They're doing that because they want to protect people who are most vulnerable. Immigrants are most vulnerable to be taken advantage of. If you take away that right from them to bring the lawsuit, then you could literally hire somebody who's an immigrant and treat them like garbage and then say they have no right to the court system.
Yes, that's true. But then once you give them all this back pay and then you I guess my question is there's like no fine line. You either put them on the books and do it legitimately so they could take out Social Security and payroll and taxes and all that stuff. But they don't have social security cards, and how are you going to
True.
actually put
So
them
what
on the
happens
books?
in reality, Jess, these cases, so discrimination cases are mostly contested, right? No one wants to admit that they're discriminating against someone else. The cases that I'm describing right now, these wage and hour cases, it's either you're dead and like it's almost like I said, shooting fish in a barrel. Either you violated the law or you did it. If you violated the law, you better come up with that damages calculation and settle it quickly, because the more you fight it, the more you're going to pay the plaintiff's attorney in fees, because the more they work on it, the more they could justify fees. A lawyer, if they take a case all the way, can easily justify 150, 200,000 on top of the award. So what happens is, I understand what you're saying, but in practice, what happens is when a defendant, or really a defendant's attorney, realizes that there's real exposure, they settle the case quickly. And in settling the case, you're ending the case. So what you're doing is you're basically paying the case to go away. So if the plaintiff doesn't pay Social Security, at least you're ending the case and you're moving on.
So the lesson is that if you are going to hire a nanny or someone to take care of your kids or clean your house or do whatever while you're working or whatever, best bet is to get them on the books, set up some kind of a payroll. Is there like a quick and easy way to do that? Do you talk to your accountant? Is there a form that you download online? Because not everyone is set up for employees in their household.
Sure. So there are, I mean, really, again, you have to consider yourself. I know it's hard under the circumstance. You're having someone come in, you want to make them part of the family and love your child the way that you love them. But at the end, what you have to realize is that legally you're an employer. Okay. So you basically have two choices. You get a payroll company involved, which is very inexpensive because it's one employee. They'll set everything up for you, and you got to give them accurate hours of work weekly, and then the payroll company will issue checks. Or you could hire a third party to do that. Sometimes you could hire a nanny service, and the nanny is the employer, and they'll take care of it. But the only one caveat to that is technically now you're a joint employer. So the nanny works for this nanny company, but they also work for you. If the nanny company doesn't pay them correctly, which I've seen, then they could sue the nanny company and you. So you better make sure that you use a reputable company and you're looking out and at least are somewhat familiar with the laws that I'm describing. So you can kind of like look at it on your own and say, okay, I'm covered.
Okay. And things to look for, is there a checklist available with, things to look for a nanny company to make sure they're doing it right? If you think
in New York, because that's primarily where I practice, you should really look at the wage theft laws in New York. If you Google that, they're going to come up with a checklist of things that you should be doing. Like I said, every check has
to. Say that again. Wage what?
The Wage Theft Laws Act. Wage Theft Laws Act. Okay, you Google that, it'll come up. For example, every time that you change someone's rate of pay, you have to give them a document that shows this is what your pay is changing to. This is your hourly rate. This is your overtime rate. And then the pay stubs have to have requirements of what they have to include as well. So these are things that are kind of easy to find out, just do a simple Google search, but very, very important and could save you a ton of headache moving forward.
Yes. Are you allowed to mention the famous person and the recent case?
Well, it is in the paper, so it was Mark Anthony, and in this case, it wasn't a nanny; it was a housekeeper.
That's J-Lo's ex-husband, one of J-Lo's ex-husbands.
Yeah, she the time that we were suing, she had already moved on, or else, it's funny because some of the female attorneys in my office really wanted the deposition to happen, but we settled well before.
Oh, that's funny. And it's even more funny that she was in that movie Made in Manhattan, all about in a hotel, and they ended up doing that to their housekeeper. But it was settled, and she did end up getting back pay, right?
I can't really go into the damages, but it was resolved.
It was in the article, so it was public, like $500,000.
That was in the article. I can't comment if that's accurate, but that's in the article, and it's my client was very happy. I could say that.
Okay, well that's good, but that just shows you how it can really bite you in the ass whether you're famous or not.
Yes, and the statute of limitations goes back 6 years.
Oh.
So that's a big issue, right? So let's say you fired somebody 2 years ago or 3 years ago, you think you're totally out of safe. Chances are you are. If they haven't done anything within the first year, they're not going to do something. But technically, you could be liable for up to 6 years.
Now, how long does it take for someone to be working in your house where they're termed an employee of yours? Like
Well,
my cleaning lady comes, is she my employee because she comes once every so often?
that's a great question. So there's always a balancing act between whether or not the person is an independent contractor or the person is an employee. So for an independent contractor, you could pay them for the day, right? You don't have to pay time and a half. But some of the things they look at is direction and control.
Sorry, my dog just.
Do you have control over the hour?
Okay, go.
Yeah. Do you have complete control over the hours worked? Can you tell them not to accept other jobs? So like, let's say a maid comes into your house once a week and then works other places too. Chances are she's going to be an independent contractor. Also, I mean, if we're getting very technical, it's better to hire somebody who has like a company established. So you can make the check out to a company versus handing cash or making a check out to an individual. Although many housekeepers are individuals. It really depends upon how careful you want to be. But I can tell you, realistically, the people who sue are generally the people who work 40 hours or more a week and have not been paid an overtime rate. So if you have somebody that, even though it's wrong, if you're paying if you're classifying someone as an independent contractor, really they're technically an employee. In other words, you're giving them the equipment, they're not using their own equipment, things of that nature. Chances are they're not going to sue you because there's no real damages there. The damages come if you owe them wages.
Okay. And if you do classify them as an independent contractor, like classifying your nanny as an independent contractor, because she may do babysitting for other families on the weekend, or he may do babysitting. Hold on one sec. Cooper!
Is this real one take? Are we going to get that in the video or
Yes.
is that edited out?
The dog is eating the cat food. It's horrible.
So let me give you the perfect example. I have an independent contractor who's an attorney. She works for me. Now, why do I feel comfortable enough that she's an independent contractor versus an employee? Number one, I don't tell her what hours to work. She makes her own hours. Number two, if she wants to work on her own law firm or she wants to work at another law firm, she could do that. I can't control the fact. Equipment, I don't give her a computer. I don't give her her cell phone. She uses her own equipment. So all those things within itself kind of shows that she's more an independent contractor versus an employee. So it's really, you have to kind of, again, I turn to Google a lot. Even as an attorney, you get good information. If you Google like independent contractor versus employee, they'll give you those kind of like scales. And you're never going to fit into all. As long as you fit, if your designation was an independent contractor and most of the things are, show that they're an independent contractor, then you're okay. If they're really an employee, you better sit them down and have that discussion and say, hey, listen, I can't pay you on a 1099 anymore. We got to start making you W-2, W-4, taking out taxes, whatever it might be, because technically you're an employee.
Okay. All right. So you have to declare someone who's going to work in your house, like a nanny, that you have to have that conversation and say, are you going to be an independent contractor? Or maybe you have to declare it. And either way, there's a document.
Right, you're the employer. If I had a nanny for many years. When she came in here, I said, listen, you're an employee. I gave her documentation. This is your wages. These are the hours you need to be working. This is your overtime. We're very formal. We took out taxes. You give them a paycheck every week because nannies have to be paid every week. They can't be paid every other week. Just part of, again, this New York State,
nanny law.
Basically domestic workers law. They have to be paid weekly. So that's really it. It's as the employer, you have to make that determination. If this person just comes to babysit, let's say once a week every Saturday, they're not an employer. They're there once a week. But you can't really fire them. I mean, I guess you can, but not in a sense that there's no employee-employer relationship. They could work for other people. But if you really control if the person could work for other people, you're designating their hours. You're giving them constant assignments. You're giving them the equipment, and technically they're an employee.
Yeah, boy, oh boy, this is like hot stuff for people to know right now. Sure. I don't know if people. I'll make sure that they know. We'll share this all over the place.
All right, that sounds great.
Okay, I think you're good. I think this is a lot to digest. I have to go back and rewatch this and take more notes.
Yeah, I think this is great for your viewers and listeners. I think it starts a conversation, and if you're doing something wrong, at least you're going to know that you're doing something wrong, which would cause you to either speak with an attorney or accountant or do your own research. But a lot of people, they think it's all fun and exciting to start a business, but they don't realize there's a legality, there's a legal side to it, there's an accounting side to it. You could be subjecting yourself to a huge lawsuit, which when you first start out in business could end your business. So you got to be aware of this stuff.
It's frightening. It really is frightening. And then, to boot, small businesses they're not getting as many benefits as, large businesses. They don't have economies of scale. They don't have, insurance plans that'll provide them with large groups and large discounts. Like, we're getting it from all angles being small business owners. I don't know where the benefits are, because we're opening ourselves up to such liability and exposure, and still having to pay more in health insurance. It's crazy. I don't know why I do it.
If you're going to do it right. If you spend a little money, it's worth a lot of headaches. Spend a little money on a lawyer and accountant. Make sure you're just doing things right, because you don't want to start to expand and then all of a sudden you're crippled where it's going to ruin your business. It's really, obviously it's a very light conversation, but it could have serious ramifications.
Yeah, definitely. And you've been doing a lot to market your business and yourself, because you are a lawyer, but you're still a business owner. And, while you want to see justice for the people, you still want to, pay your mortgage and your employees as well. So you've been doing an awful lot with your videos, and I appreciate it, because I actually turn to you when I want to get some free advice on your podcast or Zoom, whatever you call it, when you put it up there on LinkedIn.
Yeah, we do a lot of different things, but I follow you as well. I thought your career has been terrific. I always like your videos with the Throwbee and everything else, really exciting. And obviously Gary Vaynerchuk is I watch and listen to his podcast all the time, and I see a couple of things with Howard Stern. So we have a lot of people in common that we kind of like share,
it's fun. Interest. It's fun. I mean, like the most inspiring person I remember was, like my Aunt Ruthie and Uncle Solomon, the sock business that they created. But now people have like so many people at their fingertips to turn to, just to get that daily inspiration and see what they're doing and check in and get new ideas.
That's the beauty. The knowledge is at your fingertips. You just have to know it's there and seek it. So anyone starting a business could really, it's no more the trial and error. You actually could learn and have an entire roadmap. So it's actually an exciting journey. And I'm again, 20 years now, I can't believe it, but 20 years into my law firm basically, and still growing, still hustling and enjoying the ride.
Yeah, I think it's even funner now. It's fun. I don't know why, but totally funner now. Pandemic aside, of course, because that sucks in its own way, but also good in its own way. It's caused people to pivot, and I started this podcast, so that's fun.
Awesome. That's great. I love it. Keep it up.
And you went to camp. Wait, I'm going to finish off on our camp story, because right in the beginning we talked about camp, and I just have to I wish I had gotten that on tape, as we used to call it. But you went to camp.
Yeah, so my son normally goes to sleepaway camp. It was canceled because of COVID-19. So what the camp does, I guess to try to make a little extra revenue, is they do something called family camp. So you go up to camp with your family. They give you an entire bunk. So you have like 10 showers, 10 toilets. You're sleeping on a mattress like this thick. And that's just the worst part of it. But everything else was terrific. Breakfast, lunch, and dinner like a camper. The older camper comes out with a bag of chipwiches, and all the adults run and grab the chipwich and, moving the kids out of the way so you get it before they do.
And your kids said you're embarrassing
me at night and oh my God, when I was, so I'm 47 now, and I'm coming to the reality of I'm not always going to be as healthy and active as I was as a kid. So I kind of have like a new rule, which is I never say no. So my kid says, "Dad, come tubing with me." I'm like, "Yes, ready to go." So it's me and my son. We're on this tube, and the guy who's riding the boat is definitely around my age, and I know he's messing with me. I know in his mind, he's like, I am going to make sure that this old man falls off this tube. And I was not going to let that happen. So I was holding on for dear life, going over these waves, and I'm like, I am not going to fall off. Sure enough, my son, who's 15, he fell off, and I'm like, okay, victory. So we did that. We did the rock wall climb, and now the camps are over. But again, some of the camps, I guess they got a lot of positive feedback from people like me who really enjoyed it. So if you do have a family, whether or not your kid goes to sleepaway camp, I understand it's open to everybody. Definitely look into it if it's before or after the season next year. It was just a blast.
That is great. See, that's like a pandemic memory. This will be a forever memory for you and your family. And I'm so glad
100%.
that you guys got the opportunity to do that.
100%.
And chipwiches taste so much better at camp.
Especially when it's a hot day. Oh my God, nothing better. Nothing better.
That's awesome. I love it. All right. Thank you so much for spending so much time and giving us all of this information. I do have to go back and take notes and just kind of recap everything that I've learned as a small business owner and everything. So this
Awesome.
was,
I think it's a great service that you have, Jess. It was great catching up with you. I don't know if you said it out loud, but we went to Albany together. So I've known you for many, many years. So it's great that you're doing
for
this.
Too long.
Yeah. And great to catch up. And I can't wait to see it.
Awesome. I wish you much success.
Great, Jess. Talk to you soon.
All right. Take care. Thank you so much. Bye-bye.